FDM versus Manuel Chang and others.
Right, who's here for the
That's not 100% protection.
My lady, my name is Ashad Code. I'm here for the applicant.
Be infected, and that somebody, even though they're vaccinated, will get serious.
Sorry, someone has not muted their microphone. Who's here for the first respondent? Second respondent?
As a consensus, my lady, I appear for a second, third, fifth, and sixth respondents.
Right, and for the fourth respondent?
My lady, I appear for the fourth respondent.
Right, and the seventh?
My lady, I'm appearing for the seventh respondent.
Right. Thank you, counsel. Just two announcements. The judgment is very long, so I'm not going to read 75 pages fully, but it is an overview of my judgment. The written copy will be available next week. And I just want to thank counsel who appeared before me for their very thorough and extensive arguments and their heads of argument as well. Every counsel contributed significantly to this judgment. Right, so I'm going to mute my video because of the instability of the Wi-Fi, and I'll continue. Introduction. The myth that corruption has no victims is a dangerous fallacy. Corruption causes disastrously inefficient economic, social, and political outcomes. It diverts public resources from critical development projects to less productive, less job creation, and less growth spurring opportunities. It makes poor nations poorer. Facts broadly. In 2013, bankers in Europe and business people based in the Middle East and senior politicians and public servants in Mozambique conspired to organize a US $2 billion loan to Mozambique. This is an incredible 12% of the GDP of one of the poorest countries in the world. Can I ask all parties to mute their video, please? Yes. The loan was kept hidden. None of the borrowed money except bribes went to Mozambique, and there were no services or products of benefit to the Mozambican people. This triggered a response from civil society, and in particular the applicant in this matter, who is the Forum de Monitoria do ORCAMENTO, abbreviated as the FMO. It is an umbrella organization of various Mozambican civil society organizations. It addressed the question of corruption and asserts in its founding affidavit that corruption is a pandemic that scourges the African continent. Like South Africa, Mozambique is no stranger to the corrupt officials, abuses of public power, and a greedy diversion of monies intended for public good to be pocketed by politicians. The first respondent, Mr. Chang, stands accused of corruption of the highest order. He's charged both in the United States of America and the Republic of Mozambique for various counts of corruption and fraud committed while he was the Minister of Finance in Mozambique. He allegedly abused his public office to funnel foreign funds intended for community upliftment, and these foreign funds were mainly from American investors. As at this stage, Mr. Chang has not yet faced a court on these charges. In 2018, the American authorities insisted that he be arrested whilst he was in South Africa, and he has been incarcerated here ever since. The United States of America requested that Mr. Chang be extradited to that country to stand trial for the alleged misdeeds, and shortly thereafter, Mozambique also requested that Mr. Chang be extradited to Mozambique to stand trial. The applicant really is an umbrella organization of some 19 Mozambican non-government organizations, and they are a non-profit, non-governmental organization organized under the laws of Mozambique. Petra, could you please ask people to mute their video?
Can Court 9D, the guest in Court 9D, yeah, thank you, Judge, I see that.
The main object of the applicant and these 19 NGOs is to deepen the democracy and development in Mozambique. And the question of its legal capacity to sue and be sued is really not a central consideration in these proceedings. In the previous application, Chang 1, the court found that the applicant did have locus standi to sue. Of importance is that the focus of the applicant is to address what they describe as widespread government corruption and maladministration in Mozambique. They assert that the members of Mozambican society are poor and they are impacted by this bribery and corruption. They were very concerned by the fact that this investment was diverted as it was intended to develop a substantial portion of what would have provided work and income to many members of the Mozambican society. This fact is not disputed. In fact, the deponent on behalf of the seventh respondent asserts that that its purpose is to bring Mr. Chang and other members of that group that stole or that redirected all this money. As from early on, the seventh respondent, the government of Mozambique, contends that it's been very serious in bringing to book the perpetrators of the so-called hidden debt scandal, corruption and fraud perpetrated against the people of Mozambique. The first respondent is really the primary or principal protagonist of this crime, and Mozambique, the government of Mozambique, points out that it has already 19 defendants who are facing prosecution in Mozambique. The government of Mozambique contends that it was really a central figure in bringing Mr. Chang to book and to the place where he now is incarcerated in South Africa. The government also points out that Mr. Chang and his co-conspirators took part in a large securities fraud scheme in which they arranged this $2 billion loan. And these were for projects that would benefit Mozambique, in particular maritime security projects. And unfortunately, all these funds were diverted illegally. And Mr. Chang signed guarantee on behalf of the government of Mozambique for all these loans, thus making Mozambique liable to repay these loans. The question of the amount and the comparison with the GDP of 12.7 is also illustrated by the government of Mozambique, thereby describing very carefully the size of the potential situation, and of course it also supports what the applicants say in regard to the effect on this country. Can I just pause here? Petru, there are a lot of people wanting to come onto the platform. Can you please stop them? There is a YouTube. I didn't announce that at the beginning. There is a YouTube. We're having a replay now of what happened previously during the hearing. People are coming onto the platform. They're not muting themselves. And please don't allow anyone further in.
Okay, Judge, I'll do so.
Okay, now I'll please ask Mr. Novunga to mute yourself or to leave this platform and watch this judgment on YouTube. I'm not going to continue until you mute yourself.
Mr. Novunga, please switch off your camera.
Right, I'll continue. The submissions made by the parties in this court are as follows, and I'll start with those by the second respondent. On behalf of the second respondent, being the Honourable Minister, it was contended that the decision he made to return Mr. Chang to Mozambique and changing his earlier decision to send Mr. Chang to the United States of America is a rational decision. In this regard, reliance was placed on the case of Scalabrini, and in particular, the reference to the following quote: "All that is required is a rational connection between the power being exercised and the decision, and the finding of objective irrationality will be rare." And this, of course, is the very opposite of what the applicant contends for. Reference was also made by the second respondent that the test for rationality was referred to by the Constitutional Court in the matter of pharmaceutical manufacturers. The decisions must be rationally related to the purpose for which the power was given. Otherwise, they are in effect arbitrary and inconsistent with this requirement. On behalf of the second respondent, it was submitted that there was a rational connection between his decision and its legitimate purpose, and he was acting within the scope of legal authority, and the decision that he made was rationally connected to the facts and information that were before him. Reference is also made to the case of Belporto, and I quote, "The fact that there may be more than one rational way of dealing with a particular problem does not make the choice of one rather than the others an irrational decision. The making of such choices is within the domain of the executive. Courts cannot interfere with rational decisions of the executive that have been made lawfully on the grounds that they consider that a different decision would have been preferable." The second respondent also criticizes the grounds of review that the applicants seek to ask the court to find, and those include that the applicant has not referred to any facts from which it appears that Mr. Chang enjoys immunity. The second respondent submits that Mr. Chang does not enjoy any form of immunity from prosecution after he ceased to be a member, and he was not a member of Parliament at the time the minister made the decisions. The opinions of experts in Mozambican law were brought to the minister's attention, and the minister was satisfied that that opinion precluded any immunity defence that Mr. Chang could raise. The minister also took into account that other persons have been indicted for the offence, and the minister relied on the conclusion that Mr. Chang could be successfully prosecuted in Mozambique, and therefore it is incorrect for the applicants to contend the contrary. There is a proper warrant of arrest according to the second respondent for the arrest of Mr. Chang, and furthermore that the minister is required in terms of Section 11A of the Extradition Act to make a decision and to deliver Mr. Chang to Mozambique based on the information before him at the time of the decision to extradite Mr. Chang to Mozambique. What the minister does not explain is why he changed his mind. That is, it is not evident from reasons on the record. It's also clear that he changed his mind and did not record those decisions. Those decisions came about on the 31st of August, and the applicant contends that the reasons of the 31st of August should not be admitted for reasons of lateness, and that they are reasons made up clearly ex post facto. The second respondent also contends that the applicant confuses the reasons for a decision and the written recordal of the decision as being a legal necessity, and that the recordal of the reason should in fact be in the record. On behalf of the second respondent, it was submitted that it is sufficient that his reasons were delivered on the 2nd of September. There is nothing, so they contend in Rule 53, which precludes written reasons from being filed after the record. Close reference will be made to that legal proposition. And the second respondent also disputes that it is in the interest of justice that the applicants demand that Mr. Chang be extradited to the United States of America, and furthermore that this court cannot substitute its own decision, save in exceptional circumstances, and that there are the applicants have not made out a case for exceptional circumstances to warrant the court making a decision or substituting the decision of the minister. The second respondent also urges the court to take into account that there is no bias on the part of the minister. The court is mindful of these submissions, but the court also has to take the entire conspectus of evidence into account. I now deal with the submissions of the fourth respondent, The fourth respondent is the Helen Suzman Foundation, and they are also a non-profit organization which also has an interest in highlighting and preventing the scourge of corruption, not only here but globally. The Helen Suzman Foundation only seeks to highlight 4 aspects which affect the rule of law in this matter, and they include the following submissions: that all exercises of public power are subject to judicial scrutiny, and that the international law implications of the minister's decisions do not mean that this decision is shielded from the court's oversight. The foundation also analysed the record and submit that the minister's reasons fail to advance the rule of law, constitutionality, and human rights, and there is no persuasive reason why Mr. Chang would be properly tried, would be arrested and properly tried in Mozambique, and that the interests of justice would be served if he were extradited to the United States of America. The third point that they highlight is that the minister's decision must be located in the record and not editorialized written reasons delivered after the record, which are not confirmed independently by the record. And this, of course, is a directly disputed situation by the minister, who says Rule 53 does not require that the reasons be recorded in the record. However, that particular aspect will be tested, those 2 submissions will be tested when I deal with the question of legality and whether the minister's decision was rational in the circumstances. It is trite law that the exercise of public power, including executive action, is subject to the Constitution and review by the courts. And of course, the courts are mindful not to overstep the mark or overreach into what would be the realm of the executive. However, the courts are fully entitled to assess and weigh whether the principle of legality has been breached or not. The Helen Suzman Foundation also referred to a number of statutes and conventions. This includes PRECA, South Africa's commitment to strengthen measures to prevent and combat corruption and corrupt activities. Section 35 of PRECA provides that even if the act alleged to constitute an offence under this act occurred outside the Republic, a court of the Republic shall, regardless of whether or not the act constitutes an offence at the place of its commission, have jurisdiction in respect of that offence if the person is to be charged. I was also referred to a number of international instruments, and this includes the United Nations Convention Against Corruption, the AU Convention Against Corruption, the OECD Anti-Bribery Convention, and the SADC Protocol Against Corruption. And it is quite clear that corruption is a transnational phenomena requiring interstate cooperation, and there should be effective eradication through concerted efforts of everyone concerned. And the minister's decision in this matter is, of course, a critical aspect. I was referred to Article 4E of the SADC Protocol on Extradition, and I quote, If the person whose extradition is requested has, under the law of either state party, become immune from prosecution or punishment for any reason, including the lapse of time or amnesty, that extradition shall be refused. Now, the question of immunity from prosecution and punishment is an aspect that I shall return to, but of importance is the attack by the Helen Suzman Foundation, which is consistent with the submissions by the applicant on the fact that the minister's decision fails to advance the rule of law and is unlawful and irrational. And that the stated objective of the extradition is not achieved by extraditing the Mr. Chang to Mozambique. The seventh respondent also filed a substantial answering affidavit, and the deponent was the Minister of Justice, and in particular, I have regard to the arrest warrant that was issued, and I read into the record the arrest warrant, since the arrest warrant has been attacked by the applicants, the competence of the arrest warrants. I quote that the judge of the Criminal Court Division of the Maputo City Judicial Court issued a warrant as follows: the competent authorities under that particular case number, who upon receiving this warrant duly signed by me and in fulfillment shall arrest within the whole extension of the Mozambican territory the defendant identified as MANUEL Chang, a Mozambican national, to be charged, as he is charged, with passive corruption for illicit acts contrary to Article 7 of the law and contrary to Article 5022 of the Criminal Code, based on unlawful participation in business, and it's difficult to understand this arrest warrant, but it is quite clear that it is for money which has been laundered and what is a criminal act. The minister, the foreign minister, confirmed that the deponent, Dr. Alberto Paulo, to the seventh respondent's answering affidavit, is the Vice Attorney General of the Republic of Mozambique, and I correct where I said the Minister of Justice in Mozambique. The Mozambican government urges this court to take into account that it is not a question of whether Mr. Chang will likely face prosecution in Mozambique, but that he definitely will. And Dr. Paulo really speaks in a position that he knows the law, and that what he is telling this court is the law of Mozambique. I have ever not been referred to any cases by Dr. Paulo other than his strong submissions that the Mr. Chang will definitely be prosecuted when he gets to Mozambique. And he also refers to the fact of the international warrant, which I shall refer to, and states that that both warrants remain enforceable, and in particular the international warrant issued by the Supreme Court of Mozambique has not been withdrawn, and there is an assurance from him that Mr. Chang will definitely be prosecuted, and that it doesn't matter that the international warrant was issued more than 2.5 years ago. The moment Mr. Chang touches Mozambican soil, he will be indicted. It is quite clear that the indictment is a provisional indictment against Mr. Chang. And here again, he's indicted and being charged with the violation of budget laws, passive corruption for unlawful acts, and abuse of his position, and criminal association and embellishment. That has not been withdrawn. The applicant attacks the lawfulness of those warrants, an aspect that is dealt with further on in my judgment. The heads of argument of the seventh respondent also urge on the court that I must accept that the applicants have not established a prima facie right, and that should be the end of my inquiry. They have not shown that there will be harm suffered by them if Mr. Chang is extradited to Mozambique. Petrie, you're going to have to stop people coming onto this platform. I'm going to take a short adjournment until you...
Judge, I don't invite them. I don't know who's admitting them, because it's definitely not me. Someone is admitting them and not me.
I think what we must do is clear the platform completely and just allow the lawyers in. This is on YouTube. So I'm going to take an adjournment. Petra, please terminate the meeting and we can restart it only with the lawyer.
Judge. Okay.
Judicial Court. The applicant submits that that there is still no guarantee about the legal process that Mr. Chang will undergo in Mozambique, and that this court should ensure that there is no possibility that he will not face the full brunt of the law should he be returned to Mozambique. They submit that the applicant submits that extradition is a critical tool in ensuring that criminals cannot use their resources to leave a country's territory to avoid criminal accountability. The applicants are concerned that having the resources which Mr. Chang has will result in an easy step for him to leave the country. The international warrant of arrest is defective according to the applicants, in that it also provides for Mr. Chang to be arrested outside the territory of Mozambique. They therefore contend that the warrants of arrest are not valid. The public prosecutor of Mozambique, in the provisional indictment sent to the minister, the second respondent, explained that the warrant of the 19th of January 2019 did not comply with pre-trial detention timelines, and because of the concurrent extradition requests from Mozambique and the United States of America to the South African authorities, the prosecutor then tried to justify why a second warrant was necessary in order to make sure that the pre-trial detention was met. The public prosecutor reapplied for a warrant, and according to the prosecutor, is that the 19th of January 2019 international warrant is no longer valid for its failure to comply with certain timelines under Mozambican law. This to me is concerning, since the international warrant has not been withdrawn as far as the papers put before me. And there is within Mozambique, the justice system, this inconsistency about how the two warrants are to be assessed. There is no proper explanation except for that brief reference as to why a second warrant was to be issued. The second reason asserted by the applicants is that the warrant was issued whilst Mr. Chang was a member of Parliament, pursuant to a special Mozambican legal procedure, and that notwithstanding the fact that the minister was told by the government of Mozambique that Mr. Chang renounced his membership of Parliament on 19 July 2019, it is still unclear whether the warrant could still be enforced against Mr. Chang when he is no longer a member of Parliament. This leads to the assessment as to whether this would result in functional immunity, being that whilst he was still a minister, or whether Mr. Chang himself has waived his right to immunity. He certainly hasn't at this stage. The third reason contended for by the applicants is that the warrant is over 2.5 years old, and it is unclear whether the warrant is valid as a matter of Mozambican law, which could prescribe timelines for the validity of such a warrant. On the contrary, given the prosecutor's reference to timelines, the implication is that the international warrant has prescribed, and as I've already stated, it may be defective, and in particular, its reference to Mr. Chang being arrested outside of Mozambique, and of course, that cannot happen. He would have to be extradited to Mozambique. He cannot be arrested in another country outside of those extradition procedures. The applicant also contends that the minister does not give positive reasons for why the warrant is valid. He simply denies that the warrant is invalid, and he makes no attempt to address the discrepancy between the two warrants and the provisional indictment and arrest warrant of 19 January 2019. He also does not explain whether the arrest warrant is valid and simply accepts the bald allegation by the government of Mozambique that the 19 January 2019 warrant is valid. And of course, the government of Mozambique also does not raise or address the questions on the discrepancy between the prosecutor's reference to timelines not being complied with and for the need to issue the additional Maputo City warrant. The government of Mozambique presented in its answering affidavit another arrest warrant for Mr. Chang, and which I've referred to is dated the 14th of February. And the point made there is that this warrant of the 14th of February 2020 was not before the minister when he made his decision. It only came in these proceedings after the filing of the answering affidavits. The points made about this new warrant is that the minister's decision to place reliance on the first warrant of arrest, since the second warrant was not before him, is irrational. And the government of Mozambique does not explain why, on its version, there are now two warrants for Mr. Chang's arrest and for the inconsistency. It would seem to me that it would be an easy thing for a Mozambican judicial officer to issue another warrant and at any time, or changing the provisional indictment, and all this results in considerable uncertainty as to whether the extradition, Mr. Chang's extradition to Mozambique will hold. The wording of the warrants also attract criticism, and that is that it seems to me there is a crime of passive corruption for an illicit act, and it's uncertain whether the charges in the indictment will result in any substantial punishment of Mr. Chang in due course. The question, therefore, of the warrants does introduce considerable uncertainty, and is an aspect that this court must take into account. The question of immunity is also an aspect which does introduce some uncertainty, and in this regard, one has to take into account the facts in the submission made by the applicant that Mr. Chang has not claimed international legal immunity against the crimes in Mozambique. Had he waived his immunity on oath, it might well be that this would have been a compelling factor that this court would take into account. The other aspects relating to immunity is that the government of Mozambique does not explain whether it follows from his resignation as an MP that Mr. Chang can now be prosecuted for a crime done during his term of office. It may well be that Mr. Chang could put up a defence that he is immune from prosecution, as all this occurred during his term of office, even though he's not a member of parliament. There is no assurance by the government of Mozambique that Mr. Chang will definitely not be immune from prosecution for his past conduct as a member of parliament. The immunity, it is uncertain whether it means personal immunity while an incumbent of the office. And thirdly, Mr. Chang and the Mozambican government offer contradictory accounts of his immunity. Mr. Chang has submitted that he must be surrendered to Mozambique so that he can have his immunity lifted. That was in previous proceedings. He then, in plain contradiction of this statement, says that the immunity is now moot as he has resigned from Parliament and there is a new Parliament in Mozambique. The other relevant factor is that in the supplementary submissions by the Mozambican government on 26 May 2020, the assertion is now made that Mr. Chang never enjoyed immunity for the crimes of which he is accused, and therefore this change of stance is a further factor. I'll now move on to the reasons given by the Minister and the lateness of those reasons. The document was filed out of time. It was filed on the 31st of August. It was signed on the 31st of August and 2021, and only filed on Thursday, the 2nd of September 2021. The Minister has applied for condemnation in his answering affidavit, but the applicants contend that this falls short of the kind of condemnation which must be pleaded as stated in the Constitutional Court in the matter of Derek Grootboom versus National Prosecuting Authority and the Minister of Justice. The applicants argue very strongly that this court should disregard those reasons, but there are further problems with the reasons. They are really a post hoc explanation, and the court has to consider whether these post hoc or ex post facto reasons are sufficient to justify the rationality of his decisions. It is quite clear that in several of the review proceedings, our courts have criticised post hoc rationalizations as an impermissible practice, and a number of cases have been referred to in this regard. A further consideration is the principle that post hoc reasons really amount to a moving target. The Supreme Court of America came to a similar conclusion in the University of California case, Department of Homeland Security versus Regents of University of California, a decision by the majority in an opinion led by Justice Roberts, where he found that it is a foundational principle of administrative law that judicial review of agency action is limited to the grounds that the agency invoked when it took the action. This involved the decision about the Dreamers and the Dakar decision. The court has to decide whether the agency action was adequately explained, and this, of course, the natural starting point is the explanation provided at the time that the decision was taken. In that case, Secretary Nielsen chose to elaborate on the reasons for the initial rescission of the DACA protection rather than take new administrative action, and she was limited to the agency's original reasons. In my view, the question that the decision maker did not note or make any reference to or record his decisions his decision at the time that he made it is of importance, and in particular whether ex post facto reasons can justify a rational decision. The Minister, on behalf of the Minister, it was argued that nothing in Rule 53 requires that there have to be contemporaneous reasons, but that is not a critical aspect. The critical aspect is whether the failure to provide contemporaneous reasons goes to the rationality of the decision. So I do not uphold the applicant's argument that I should not look at the Minister's decisions at all. I do take them into account, but I take them into account against the case law in this country, as well as the reference to the American courts, and therefore the weight that I attribute to post hoc decisions, in my view, are not of moment and certainly cannot justify rationality of his decision. The main consideration, therefore, is the question of the rationality of his decision. I am mindful of the letter dated the 26th of August 2021, where the Minister addressed a letter to Mr. Levitt of the applicant, and the following directive is issued by the Minister. Kindly take notice that the Minister issued an order in terms of Section 11A of the Extradition Act 67 of 1962 for the surrender of Mr. Manuel Chang to persons authorized by the authorities of the Republic of Mozambique to receive him. We are mindful of South Africa's treaty obligations towards the United States, and that there were concurrent requests for the extradition of Mr. Chang to Mozambique. All relevant legislation, submissions by all the related parties, as well as South Africa's international law obligations to support the fight against corruption were considered. Now, it is this decision which is an about-face, which the applicants contend the Minister could not make such a change of tack without explaining the change fully, and that particular assertion was a consistent theme throughout the applicant's case. Clearly, this is a challenge under the law, the principles pertaining to legality, although the applicants rely on PAJA and the illegality. I have ever considered this against the background of decisional and procedural irrationality. The applicants contend that the minister's decision is both unlawful and irrational, and make the following submissions: that Mr. Chang is immune from criminal prosecution in Mozambique. That is but one aspect that this court considers. That if he were extradited to Mozambique, that the very foundational warrant for his arrest is uncertain and unclear, and the absence of reasons by the minister is also contributes to the irrationality submissions made by them. In the absence of proper reasons for the change of tack, it is difficult to assess whether those reasons are rationally related to the decision. And they also submit that the Mr. Chang should never be extradited to Mozambique for all the reasons that have been mentioned, and to do so would be irrational, particularly in the light of the history of the matter and the change in tack by the minister. Now, the leading authority on decisional rationality is the pharmaceutical manufacturer's case, which laid down that the principle that for the exercise of public power to be valid, a decision must be taken which is rationally connected to the purpose for which the power was conferred. However, the concept of rationality also encompasses the procedure followed in reaching a decision. It is clear that our law requires that the procedure followed should itself be rationally connected to the purpose for which the power is exercised. In other words, the procedure followed must reasonably be capable of leading to the attainment of the purpose for which the power was conferred. In this regard, the cases of Orbit and Democratic Alliance are relevant. In particular, the following was stated in the Democratic Alliance case, and I quote, "The means for achieving the purpose for which the power was conferred must include everything that is done to achieve that purpose, not only the decision employed to achieve the purpose, but also everything done in the process of taking that decision constitutes means towards the attainment of the purpose for which it was conferred." In this regard, the applicants say that the minister had very high international duties, and it is a high test as to, in this particular situation where there is transnational corruption, that the standard is very high. There must be exacting compliance with the minister justifying his reason as being rational, and he should have been on notice of this particular legal provision after the Chang 1 case. He was advised by his legal advisors, and this is evident, that his decision would be subject to review. This is in a memo from an advocate, and the minister therefore had a very high duty to make sure that the decision he made was not irrational, and this change of tack should have been fully explained and justified. He was also under the International Convention obligations and SADC, and the rationality standard must reach a convincing and a higher threshold in these particular circumstances. The minister knew that at some stage he'd been misled in earlier proceedings by the government of Mozambique on this question, and that in itself required a heightened sense of analysis of the situation and a justification for any of the decisions that he would take. Furthermore, on the question of testing the rationality of his decision, it bears emphasis that there is a distinction between irrationality relating to the decision itself and irrationality relating to the procedure leading up to the decision. The presence of each of them is fatal to the exercise of power. So if one applies what was referred to as the Cameron principle, if there is an error on one aspect, being either the decision itself or the procedure leading up to the decision, then any one of those would be a killer point to set aside the decision. Therefore, the context against which the minister's decision must take place against the tests that I have referred to. In particular, the Democratic Alliance case states very carefully that the decision must be fully explained and it must of itself also be rational. The reasoning to show rationality must be fully explained, and there must be an evaluation of the relationship between the means and the end. And if the relationship, connection, or link to achieve a particular purpose is not justifiable, then in those circumstances the decision stands to be set aside. In particular, if an important aspect or relevant factor has been ignored, this is a further indication of rationality. To ignore one relevant factor or material relevant factor leads to a finding of irrationality. It was submitted by Advocate Beloy on behalf of the Minister that his decision and all the procedures leading up to the decision were fully rational, and that he exercised the power for the very purpose of considering the question of extradition. There is, in my view, however, a number of relevant factors that the Minister did not take into account, and this goes to the heart of the analysis as to whether the decision and the procedure leading up to the decision can be justified. There are material considerations about the warrant, the question of immunity, that leave uncertainty, and the question is whether the Minister's reasons have been fully explained, and in my view, certainly the change of tack has not been explained, and this is a material omission, and it goes to the very heart not only of the decision itself, but the procedure leading up to the decision. In the result and conclusion is that the decision of the Minister, despite all the submissions made on his behalf and supported in particular by the government of Mozambique, falls short of the threshold of rationality. In the absence of a proper explanation and assurances to buttress his decision, this court cannot find that the decision was rational. In the result, I make the following order. The decision by the second respondent on or about the 23rd of August 2021 to extradite the first respondent to the Republic of Mozambique is declared to be inconsistent with the Constitution of the Republic of South Africa of 1996 and is invalid and is set aside. 2. The decision of the second respondent on 21 May 2019 is substituted with the following. Mr. Manuel Chang is to be surrendered and extradited to the United States of America to stand trial for his alleged offences in the United States of America, as contained in the extradition request dated 28 January 2019. The second respondent is to pay the costs of this application, including the costs to counsel, and just a further paragraph before that order is that I concluded that I am entitled to substitute the second respondent's decision based on the rationality test and its failure to meet that benchmark. So ordered, the type judgment will be available next week. The court adjourns.
As the court pleases.
The court pleases,
As
my
the court
lady.
pleases.
As the court pleases.